I'll be quick. Just to incorporate my prior argument, under McCrary, admissibility isn't the issue. It's the serious threat to the fair trial rights. And again, under McCrary, I don't think the defendant has established her burden to show that this shouldn't be released. In terms of the medical privacy records, they haven't cited an applicable exemption that would otherwise take this out of public disclosure. This is not the type of protected health information under HIPAA. They can take her with their counselor. It's a public area.
What do you say regarding his request to simply hold off on releasing it? He says he might want to, at a bare minimum, he hasn't even seen it himself.
Certainly, Your Honor, so it's hard to establish McCrary without having seen it, and certainly we wouldn't be entitled to it until it is made available in discovery. So at this point, we're not even entitled to access until it is made available. And certainly, if Your Honor would like to have another hearing, we definitely would like to participate in that and address these issues more fully, especially on the medical and privacy concerns in that area.
All right. Does anybody else want to be heard on this issue regarding that video?
I do. I am Marie Delahunty with the Sheriff's Office. I just want to echo Mr. Guthrie's statements that we object to the characterization that we were involved in some sort of scheme or conspiracy. As Mr. Baez mentioned, he has not seen the video. He hasn't even talked to the people involved in it. He's putting forth some big conspiracy theory, so we do object to it. Our interest, obviously, is we do have a copy, obviously, of the tape, so this is a discovery issue. Once that is resolved, this is a public record, and we just stand ready to, whatever the court decides is appropriate. If they close it down, then we won't provide it. If it's a public record and it's not closed down, then we have an obligation to provide it to whomever asks for it.
Seems like, just to go ahead and deal with it, seems like a fair enough at least be able to look at this so that we can make a reasonable argument on behalf of his client. I don't really have any problem with staying the release until you've had a chance to look at it. That seems cricket. Does anybody want to be heard on that? I think that's the fair and reasonable thing to do. Ultimately, your request may get denied, but maybe you'll see you might withdraw the request after you see it. It may be something that you don't think is bad at all. Having said that, though, I do think you ought to have the opportunity to at least look at this so that you can have a chance to make a reasonable argument about why it shouldn't be released. You're sort of flying blind here, and on that point, I think you're correct. So I'm going to stay the release of that video until Mr. Baez has had a chance to look at it. You can then file a second motion. I'll promptly set it, or you can choose not to file one if you don't have a problem with it. The court would release it.
Judge, may I have a reasonable time to file a motion? Should I, after viewing it?
Well, yeah, sure.
20 days.
Well, Your Honor, I was just going to say, if we could have a set date, because our standard when we're given a public records demand is a reasonable amount of time. I've argued with many lawyers representing the media about that, but I really wouldn't want to litigate it and have to pay attorney's fees. So it would be nice if we had a date that it has to be done by.
In terms of him viewing it, right?
Well, in terms of the stay ending, because as soon as we give it to him, we have a duty to give it out as a public record if somebody asks for it.
Right. Well, what I was getting at is I suppose I would like you to go there and look at it. Can accommodations be made, or does that? Go ahead.
I offered Mr. Baez a copy of it. He indicated to me he did not want it at that time because it does immediately become a public record. So
well, that's fine.
He can come over, well, not after the hearing, but tomorrow and view it, or we can have a copy made for him
Is his
tomorrow.
viewing it at your office then make it a public record?
I think so.
Well, it's required to be given to the defendant. It's actually required to be given to the defendant right now because it's discovery, so we have 15 days to give it.
Judge, I'll wait days.
Well, I didn't see Ms. Fugate's argument in our civil lawsuit where she says we had a reasonable time to turn it over to her and we didn't.
I'm sorry, Mr. Wilson. I would request a reasonable amount of time after viewing it to file our objection, should we have any. I kind of like, I would say 20 days after filing the motion, because of the fact that there might be
20 days to file the motion after viewing it?
Yes.
You want to be heard, Ms. Fugate?
And Your Honor, 20 days seems a bit excessive for me, but we certainly, would agree that they should have some time after viewing it if they view it tomorrow, I think.
Well,
But-
filing it and getting it set are different matters.
Certainly, Your Honor.
About 10 days after doing it, in which to, I mean, the motion would be fairly simple unless you,
Well, it may be a complex issue, that's the problem. I would ask for the 20 days at a minimum, Judge. I think it's what's usually given to the state when I ask for something, I would ask the same courtesy back. I just think that there's an investigation that needs to, I need to be able to look into these things. I certainly respect whatever decision the court makes. I would just ask for 20 days.
You're just talking about him filing another motion for a protective order as opposed to a motion to suppress, correct?
Correct.
All right.
Yes.
Which is what I believe he's talking about regarding an investigation into the matter, as opposed to the release of discovery and then him seeking a protective order from our releasing it as a public record. Correct?
I think, yeah. I mean,